Okay, so when you hire a lawyer, you're putting a massive amount of trust in them, right? We're talking about your money, maybe even your freedom, your entire future. But what happens when that trust gets shattered? We're going to dive into the whole system that's supposed to govern the legal profession and, more importantly, protect you. Wow. I mean, listen to this quote. This comes straight from the chairperson of the ethics committee at the Law Society. They're not sugarcoating it at all. They're basically saying, look, some lawyers, they're just in it to get the loot. It's a pretty harsh reality, and it's exactly why we need a really solid system of oversight. So that brings up the big question, doesn't it? What actually protects you from a lawyer like that? If the very people who are meant to uphold the law are the ones breaking it, what can you even do? Well, it turns out there's a whole multi-layered system in place. Let's break it down piece by piece. First up, the gates to the profession. We're starting at the very beginning. Who even gets to be a lawyer in the first place? Because, it's not like anyone with a law degree can just hang up a sign and start practicing. There are some serious hoops to jump through. And the foundation for all of this, it's the Legal Practice Act of 2014. You can think of this as the main rulebook for literally the entire legal profession. It's the thing that brought all legal practitioners, advocates, attorneys, everyone, under one roof, with one set of standards for who gets in, how they have to act, and what happens when they step out of line. Now, right at the heart of getting admitted is this really interesting character test. Any applicant has to prove they are a fit and proper person. And this isn't about your grades, it's about your integrity, your honesty. But here's the kicker. The law never actually defines what fit and proper means. So it's left up to the courts to figure it out on a case-by-case basis. And as you're about to see, that can get pretty complicated. And yeah, because there's no clear definition, it's led to some really awful decisions in the past. Get this. Back in 1894, the Law Society tried to block Mahatma Gandhi's admission, arguing he wasn't fit and proper simply because of his Indian origin. And then in 1912, Madeline Wookey was told she couldn't be a lawyer because she was a woman. These cases are perfect examples of how a subjective test like this can just become a tool for the biases of the time. Which brings us to a more modern and really tricky dilemma. The case of Mr. Prince. He was a Rastafarian, and when he applied to be a lawyer, he was totally honest. He said he would continue to use cannabis for his religious practices, which, at the time, was against the law. So you can see the problem for the court, right? On one hand, you've got his constitutional right to religious freedom. On the other, he's openly stating his intention to break the law. In the end, the court sided with the law. They said you can't be fit and proper if you plan to defy the very laws you'd be swearing to uphold. All right, so just getting through those gates is only the first step. Once a lawyer is actually in the profession, there's a whole system to regulate what they do. So let's get into the rules of the game. The main referee in this game is the Legal Practice Council, or the LPC. It was set up by that Legal Practice Act we just talked about, and its entire reason for existing is to regulate lawyers and protect you, the public. The LPC is the one setting the code of conduct, investigating when you complain, and just making sure everyone stays in line. And this idea of the profession regulating itself is so important. For our justice system to really work, to have any real power, the legal profession has to be independent from government control. Judge Kriegler had this great quote about it. He said, "Falcons do not come from hen houses." What he meant was you can't expect to get fierce independent judges, the falcons, from a profession that's timid and controlled like a hen house. It just doesn't work. So what are some of the big rules? Well, two huge ones govern their day-to-day practice. First, and this is critical, lawyers have to keep your money, any client money, in a completely separate audited trust account. And second, something called touting is a big no-no. That's basically trying to get business in an unprofessional way. The Barange case is a perfect example. This attorney was paying estate agents to send clients his way, but he tried to call them marketing agreements. The court saw right through it, said it was a clear breach of the rules, and suspended him. Okay, but what about the absolute worst-case scenario? What happens if a lawyer completely betrays that trust and actually steals a client's money from that trust account? Well, there's a safety net for that exact situation. And that safety net is called the Legal Practitioners Fidelity Fund. Think of it like a special insurance policy, just for the public. Its entire job is to pay you back if you lose money because a lawyer stole funds they were supposed to be holding in trust for you. But listen, if you ever have to make a claim, you need to know that the process is incredibly strict and the deadlines are no joke. You have to give them written notice within just 3 months of finding out about the theft. Then they'll ask for proof, and you have 6 months to get it to them. And if, after all that, they say no, you only have 1 year to sue the fund. These deadlines are absolutely rigid. You can't miss them. Now here's the catch, and it's a big one. Not every penny you lose is actually covered. The key legal question is always this: was the money entrusted in the course of legal practice? And the courts have been really narrow about what that means. So you have cases like King v. Fidelity Fund and Metal, where lawyers were handling money for things like business factoring schemes or bridging finance. These were basically investment-type deals. And the court said, nope, that's not covered. The fund is there to protect you from theft related to actual legal work, not if you're using your lawyer as some kind of side hustle investment manager. So we've looked at the rules and the safety net, but what happens when a lawyer's conduct is so bad, so far over the line, that they just aren't fit to practice anymore? Let's talk about the final stage, facing the consequences. When someone wants to get a lawyer kicked out of the profession, the court uses a very clear 3-stage test that came from the Dassault case. It's pretty logical. First, the factual part. Did the bad thing actually happen? Is there enough proof? Second, a value judgment. Based on what happened, is this person still fit and proper? And third, the court decides on the punishment. Is a temporary suspension enough, or do they need to be struck off the roll for good? And through it all, the #1 priority is always protecting the public. And getting struck off really is the professional death penalty. But some people still try to cheat the system. Take the Masheko case. These 2 attorneys were struck off the roll, but they just went and set up a corporation and tried to keep practicing illegally. They even used a letterhead that was designed to make people think they were still qualified lawyers. Unbelievable. And that really brings us to this quote from Judge Bertelsmann, which just says it all. It's completely uncompromising. He says that if a lawyer knowingly lies to the court, that's it. They are unfit to practice, and there is only one way to deal with them. They must be struck off. It's not just a policy, it's the absolute bedrock of the whole profession. So after looking at all this, the gatekeeping, the rules, the safety nets, it all kind of brings us back to one big final question. The whole system really kicks off with that fit and proper character test at the very beginning of a career. But is that one-time snapshot of someone's character really enough to guarantee a lifetime of good behavior? I mean, the entire system of trust we've been talking about rests on that question. And it really makes you wonder, is the public actually as protected as we think we are?